Hello and welcome to my presentation. My name is Donna Lewis Taylor and I will be presenting on the Nike versus MSCHF lawsuit. And now I will begin. So for thousands of years, humans have issued trademarks before the term was even invented. Early humans such as the Roman craftspeople left their marks on all of their inventions to credit themselves as the first to discover or claim ownership of livestock at that time. However, the Romans were not the first to do this. In fact, several other groups of people like Egyptians and the Chinese left their ancient trademarks in forms of leaving symbols on sculptures, handprint engravements, etc., all to distinguish themselves as the first people to create or experience the event. The word trademark did not become used until 1266 after death, when King Henry III of England passed the first trademark law, which required bakers to add a distinctive mark to all bread sold, because bread fraud apparently was common in the mid-1200s. In the modern world, many people tend to think the concept of registering a trademark is recent. However, this serves to reinforce that this assumption is false. In this presentation, I will outline the facts of the MSCHF versus Nike lawsuit and discuss trademark infringement dispute that Nike filed and discuss both positions in settlement on this case. So in March 2021, American rapper Lil Nas X went viral after releasing a provocative video to his late song, Call Me By Your Name. The music video sparked controversy after a clip of him seducing a figure that appeared to be Satan surrounded in flames surfaced the web. Shortly after, many people around the world took their opinions to social media platforms such as Twitter, Instagram, and Facebook, sharing a mixture of creative applause and also criticism of religious insensitivity. The legal turmoil began after Lil Nas X announced his collaboration with MSCHF, which is a Brooklyn-based art collective, which basically well known for customizing different products. And what they did here was they took Nike's Air Max 97s, called them Satan shoes, and basically altered them. And what they did, if you can see in the left picture here, was they basically changed the sole and added 60 cubic centimeters of ink and 1 drop, apparently, or allegedly, of human blood. And the shoes actually was released on March 29th, 2021, and were sold for each pair $1,800 flat, and only 666 pairs were, sold in terms of inventory. And that was a pretty provocative number that was selected. 666 tends to be associated with Satanism. So anyone would, be upset about that, and I'll talk about the customer and general public reactions in the following slides. So what now? Now we know, after Lil Nas announced that he would sell his shoes on March 29th, Nike on the same day announced that they filed a lawsuit against MSCHF for trademark infringement. And the interesting thing about this is that even though the shoes sold out in less than 60 seconds upon release, Nike still decided to carry out this act, and I'll let you know my opinion later on in regards to how successful, or if they might have set themselves up for success after this. So before I move on with the analysis or discussing the positions, I just wanted to take a moment to just state what trademark infringement is And I found a really good definition by the Cornell Law School, which states that trademark law protects a trademark owner's exclusive right to use a trademark when use of the mark by another would be likely to cause consumer confusion as to the source or origin of goods. And now we will begin discussing Nike's position. So on March 29th, Nike issued a statement that says, they filed a lawsuit, and in their lawsuit, they released a statement that says, Nike has not and does not approve or authorize MSCHF's customized Satan shoes. Moreover, MSCHF and its unauthorized Satan shoes are likely to cause confusion and delusion and create an erroneous association between MSCHF's products and Nike. In fact, there is already evidence of significant confusion and delusion occurring in the marketplace, including calls to boycott Nike in response to the launch of MSCHF's Satan shoes based on the mistaken belief that Nike has authorized or approved this product. And now we'll take a look at what backs up Nike's claim. So, as mentioned before, many people, the general public, especially on social media, since it quote unquote went viral, released and just expressed their thoughts about Lil Nas' announcement. And here are a few statements. In the top left corner, someone says, never buying a Nike shoe again. Bunch of hypocrites. Crazy. They need Jesus. Someone else by the name of Kiss My Tats 81 says, this is sickening. How is Nike not involved when there's a Nike symbol on the shoe? Mitz Punky says, of course Nike is collaborating, or they would be threatening to sue to be associated with this evil blank. And another user says, you cannot say there is no agenda being pushed here. They could not make it more obvious. I might be done with Nike from now on. Others continue, this is terrible. Won't buy Nike again. You are banned. No more Nike for anyone in my family. This is disgusting. Nike should be canceled for this. So, although Nike claimed trademark infringement, MSCHF expresses that they believe their actions were justified to author the authentic shoe and resell them. According to Snopes.com, an MSCHF representative shared that MSCHF buys the shoes from Nike. Then the artists make their own creative modifications before selling them. The CEO added, we were honestly surprised by the action Nike has taken, and immediately after Nike's counsel sent us notice, we reached out but never received a response. Whaley, CEO, also added that over a year ago they released something called the Jesus shoe, which was basically the same concept of the Satan shoe, just the opposite. Different color, obviously, white, and I believe it was blue. And they claimed that Nike did not take any action. So in response to this, MSCHF issued a statement which reads, over a year ago, we released the Jesus shoes. As manifested speculative artwork, Jesus shoes conflate celebrity collab culture and brand worship, religious worship into a limited edition line of art objects. Last week's release of the Satan shoes in collaboration with Lil Nas X was no different. Satan shoes started a conversation while also living natively in its space. It is art created for people to observe, speculate on, purchase, and own. So Nike actually persisted that the company was still causing much confusion, and they actually outlined in their lawsuit the wishes for the case's settlement. And it reads, Nike prays for several repayments with hopes to receive in order that MSCHF account to Nike for any and all profits earned as a result of MSCHF's acts in violation of Nike's rights, an award of 3 times the number of compensatory damages and increased profits pursuant, and also an order granting an award of Nike's cost expenses and reasonable attorney fees. Those are just 3 of many wishes that Nike asked for. But however, the settlement in this case turned out to be, according to NBC News, that Nike and MSCHF reached a settlement in which MSCHF will issue a voluntary recall on the shoes and offer a buyback program for previously released modified Nike sneakers it called Jesus shoes, in addition to offering a full refund of the Satan shoes. So, after hearing both Nike and MSCHF's positions, I'm just going to give a brief synopsis of what I believe occurred in this case and what I offer just some recommendations that I believe Nike probably should consider moving forward. So, after all, I believe Nike dropped all charges against MSCHF because of legal fees and probably their overall priorities, of the fact that, the cost of everything, including legal fees, would, likely exceed more than that of MSCHF's reimbursement to them for this matter. I take it that Nike acted in the measure to protect their public image and preserve its current and future customers. I will say that Nike is right about the notion that MSCHF cannot return, quote unquote, return Nike's loyalty from customers, since it's a situation that's highly subjective. With this being, MSCHF would likely have this advantage because even social media outrage, as we discussed earlier, it does not serve as evidence to prove this by law. Really only ever quantitative data from, business analysts would be the strongest to support this claim, and that takes quite a while, or, at least a few weeks to observe, for Nike's claim that, customers are not purchasing from them for this matter. But in summary, I believe that Nike, intended to look out for themselves, regardless of the relationship that they may have had with MSCHF in the past. But, when it comes to brand and representation, sometimes those relationships have to break, and you have to do things such as, taking matters or taking measures to keep and uphold customer loyalty. In addition to the first sales law that gives people the right to purchase and resell product, that kind of I believe, would have left Nike into a pretty sticky dilemma, which although it wasn't, publicly discussed, but just kind of putting myself in Nike's shoes. Likely what took place in the business room was that they didn't think it was worth fighting for, especially with how big Nike's revenue is per year. If it serves any purpose, I feel Nike felt dignified walking away knowing that they at least advocated for themselves in the public eye. So that is my opinion. So in looking at the greater effect or impact, so to say, let's look at the entertainment side. So in light of the controversy, Lil Nas X's single had since debuted at #1 on the Billboard. According to NBC News, Lil Nas X revealed what the song was actually about, sharing a quote-unquote letter to self about coming out as a gay man. He shared, quoting, "I know we promised to never come out publicly. I know we promised to never be that type of gay person. I know we promised to die with the secret, but this will open doors for many other queer people to simply exist." So in looking at, this case from I'd say from a business perspective, I believe, companies and also artists can learn from this. And I believe that, ultimately, Nike, if they don't want to find themselves in a sticky situation, again, they can probably look into modifying their trademark policies, and just kind of, in order to avoid, I would probably describe this an awkward moment with Nike and MSCHF. Avoid awkward situations like this if they are more strict on, these things from the beginning, so that companies like MSCHF, would probably back off on, selling their products to not be hit with lawsuits. Because I'm pretty sure if Nike really did want to, they could have, carried it out and won. So that's what I believe. I also think that, in the end, when we look at the question, like, who benefited from this, I'd honestly have to say MSCHF, in different ways took the win, because not many people, like, I'd never heard of the MSCHF before. So actually, with the shoes selling out in less than 60 seconds, it actually brought all eyes on their company. It made people want to shop with them, because now you have this big, celebrity influencer promoting their business, as well as Nike with, issuing a lawsuit against them. So some people actually, quote unquote, get off on those types of things and want to support companies like MSCHF. So that is my opinion, and this actually concludes my presentation. If Millen, you have any questions for me, I would just look out for the feedback and respond accordingly. All right, thank you so much for your time, and I hope you have a great day, night, or whenever you watch the presentation. All right, bye-bye.